from my analysis, it is possible to state the law on presidential immunity to be this. The president is immune from criminal prosecution and from civil suit for any act or omission in exercise of his powers under the Constitution in Kenyan courts during his tenure of office. But he may be sued for acts or omissions outside his constitutional duties and prosecuted for international crimes where the treaty establishing them does not recognize the defense of immunity. The statutory limitation period shall be extended to take account of any action or suit that could not be brought on account of the defendant's presidential tenure. I make a distinction between this and the immunity that the president had under the old constitution, where it was absolute. And I would say that absolute immunity, which existed under Section 14 of the retired Constitution, appears to me to be an anachronism and an oxymoron in the context of a constitutional democracy such as we are, that upholds as part of its national values and principles of governance the rule of law, good governance, integrity, and accountability. Those values and principles, alongside constitutionalism, which denotes limited government, denotes limited government, must mean that the office of president, being a creature of the Constitution, is and must be subordinate to the Constitution, and its holder must be held to account for his acts and omissions. The president is not above the Constitution or the law, and is not a law unto himself or herself. In recognition of that preeminence and importance of the office of the president, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143.2, and the fact that Article 143.4 expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, that each act must be shown strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president, Richard Nixon, was held to have was from damages liability predicated on his official duties, official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue